Now we get to talk about something that's very, very valuable, intellectual property. What are our objectives during this block of instruction? Well, first, you'll be able to relate the nature and strategies for the protection of trademarks, to recognize the characteristics of copyrights and how to protect them, to integrate the concept of patents with how they're protected, to explain trade secrets and how they're protected, and finally, to recall how treaties expand the protection of intellectual property. Now, this last one is very, very important. In 2020, the world is much smaller than it used to be. With the internet, with travel, you're probably starting to notice that when you look at box office returns for movies, right, it's not just based on their returns in the US, their returns in Europe, but also China. As the world gets smaller, producers, creators of books, movies, paintings, worry about people in other countries copying their stuff and cheating them out of whatever profits they might have made, right? And that's where treaties expand the protection granted in the United States to creators overseas. Now, how do we define intellectual property? It's property that is as a result of one's intellectual and creative efforts rather than physical efforts. Protection for intellectual property comes from patents, trademarks, trade secrets, and copyrights. Now, what's a trademark? A trademark is a distinctive mark, word, design, picture, or arrangement used by a producer in conjunction with a product, and that tends to cause a consumer to identify the product with the producer. Very obvious examples of this would be Amazon, Marvel, and Batman. Now, anytime you see these three logos, you know exactly what you're going to get. You want something delivered to you at home? You go to Amazon. You want to see an awesome movie with a great superhero team? You go to Marvel. And if you just want to watch the greatest superhero ever to exist, you go to DC and you look for Batman. Now, trademarks are protected under common law just by using them, but that protection is local. Now, in order to get interstate protection, the trademark must be registered with the U.S. Patent and Trademark Office. The registration must then be renewed between the 5th and 6th year, and after that initial renewal, it has to be renewed every 10 years. If you fail to renew a trademark within the allotted time period, another person could use your trademark, right? An example of this, have you ever heard of the superhero character Captain Marvel? Yeah, you're probably thinking about Captain Marvel in the Marvel Universe. That's not the original Captain Marvel. The original Captain Marvel is Shazam. The company that published Captain Marvel went out of business, and it took DC many years to acquire that particular character. In the interim, Marvel Comics created their own Captain Marvel. By the time DC began to publish the original Captain Marvel, they had lost their trademark, so they had to rename Captain Marvel as Shazam. Now, what are our remedies for trademark infringement? Well, first, money damages, right? And second, an injunction. Now, money damages, very, very simple, right? When someone uses your trademark, they have to pay you for the damages that you incur by their stealing your concept. An injunction is basically an order from the court to stop using it. Trademarks can be used in interstate commerce and can be protected under the Latham Law. The Latham Act, also known as the Trademark Act of 1946, is the federal statute that governs trademarks, service marks, and unfair competition. It was passed by Congress on July 5th, 1946, and signed into law by President Harry Truman. The act took effect on July 5th, 1947. The purpose of the Latham Act is to ensure that trademarks are exclusive to their users, as well as reduce consumer confusion when identifying well-known goods or services, and it's also known as the Trademark Act, once again. A lot of times you would have competitors who would name their products or design their products to look very much like a top-selling product, right? And this act was designed to alleviate that problem. There are several types of marks that are used to identify products. First, we have a service mark, right? A service mark is used in conjunction with a service. Second, we have a product trademark, right? This is affixed to the good, its packaging, or its label. Third, we have a collective mark, right? It's a mark identifying producers belonging to a larger group, for example, a trade union. And finally, a certification mark, right? This mark is licensed by a group, right? Big example, UL Tested or Good Housekeeping Seal of Approval, right? And it identifies that something's been certified, it's been tested. Next, we have trade dress. Trade dress relates to the overall appearance and image of a product. Trade dress is entitled to the same protections as a trademark. Now, to succeed in the claim of trade dress infringement, a party must prove three elements. First, the trade dress is primarily non-functional. That means that it's just a design to make the product look different, but it has no practical application, generally speaking. Second, the trade dress is inherently distinctive or has acquired a secondary meaning. And third, the alleged infringement creates a likelihood of confusion, right? Real great example of trade dress, right, is the shape of the Coca-Cola bottle. The shape of the bottle in of itself is non-functioning. It's just meant to identify the Coca-Cola bottle as being different than other bottles, right? And at this point in time, because the shape of this bottle has been around for so long, right, it has a secondary meaning. If you see that shape, you automatically know that it's Coca-Cola. Now, if another product had a bottle in the same or similar shape, it would create confusion because this is an iconic shape identified with the Coca-Cola brand. Here we have an example of trade dress infringement. You have Dr. Pepper, a well-known national brand, and Dr. Publix, a competitor. If you notice, the shape of the bottle is the same. The layout of the tag is essentially the same. The name is very, very similar, starting with that Dr. Pepper, Dr. Publix. It kind of rhymes. And if you're not paying attention, right, you could easily grab Dr. Publix believing that you have a bottle of Dr. Pepper. Next up is the copyright. Copyright protects the fixed form of the expression of an original or creative idea. An example of copyrighted material includes books, periodicals, musical compositions, plays, motion pictures, sound recordings, lectures, works of art, and computer programs. The feature that all of these things have in common is that they can be perceived by other people, right, other than the creator. Now, the length of copyright protection is the life of the creator plus 70 years, right? So it protects the creator for his or her entire life, then it protects the creator's estate for an additional 70 years, right? Those would be the heirs. Now, there are two primary remedies for copyright infringement. First is monetary damages, right? The question comes in is how much financial harm, right, did the copyright infringement cause the holder of the copyright, right? Frequently, there'll be a fine plus profits, right? So whatever the person who engaged in copyright infringement earned, they have to pay that to the copyright holder, right, plus a penalty. Second is an injunction. That's basically a cease and desist order from the court saying that you cannot uses copywritten material. Now, the most common defense for copyright infringement is the fair use doctrine. The fair use doctrine provides that a portion of copyrighted work may be reproduced for the purposes of criticism, comment, news reporting, teaching, scholarship, and research, right? Now, if you look at these things, I like criticism the best. If somebody critiques your book and you don't like the critique, right, were it not for the fair use doctrine, right, you could sue them for doing that, right? Likewise, if I take an article from the New York Times and I include it in my lecture in class, right, were it not for the fair use doctrine, I could be sued for that. Fair use is a judicial doctrine that refers to the use of copyrighted material that does not infringe or violate the exclusive rights of the copyright holder. Some use is fair because it does not impact adversely on the inherent value of that copywritten material. As a point of clarification, we have to talk about what counts as fair use. Now, subject to some general limitations that will be discussed later, the following types of uses are generally deemed fair uses. 1. Criticism and commentary. For example, quoting or excerpting a work in a review or criticism for the purpose of illustration or comment would normally be fair use. 2. News reporting. Summarizing an address or article with brief quotations in a news report constitutes fair use. 3. Research and scholarship. Quoting a short passage in a scholarly, scientific, or technical work for illustration or clarification of the author's observations would be deemed acceptable. 4. Non-profit educational uses. When teachers photocopy a limited portion of written works for classroom use, this is normally acceptable. Notice I emphasize limited portion. And finally, a parody. Parody is a work that ridicules another, usually well-known work by often imitating it in a comic way. Right? These would be fair use. When your favorite comedian imitates a speech, when your favorite comedian imitates a TV skit. All right, for me, when Dave Chappelle made fun of R. Kelly, when he sang that song dressed up like R. Kelly. Determining whether the fair use doctrine provides a valid defense to a claim of copyright infringement, Section 107 of the Copyright Act requires that the court weigh in on the following 4 factors. 1. The purpose and character of the use, including whether the use is of a commercial nature or not-for-profit nature. All right? Not-for-profit, you're probably good to go. Commercial, they have to look a little further. 2. The nature of the copywritten work. 3. The amount and substantiality of the portion used in relation to the copywritten work as a whole. And 4. The effect of the use on the potential market for or value of the copywritten work. 3 and 4 kind of go hand in hand. And once again, if you take an amount so great as to give up the entire copywritten work, right, the effect on the potential market for that work or the value of the work is greatly, greatly diminished. If I print 1 page from a book, the book still has value. If I print or copy 95% of the book probably has no value because it would be out there for free. Many years ago, all right, that was one of the issues with Napster, where people were sharing music online. All right, that was copyright infringement. And if I'm giving away a song, what is the value of that song, that copywritten work, right, to the artist who created it and the songwriter who wrote it? All right, it goes down to 0. Who would pay for something they could get for free? In addition to the laws signed by President Harry Truman, there have been a few extra copyright acts. One, No Electronic Theft Act of 1997. This makes it illegal for a person not only to infringe on a copyright for commercial purposes or financial gain, but also to reproduce or distribute for no financial gain the copywritten work of another. Once again, that goes back to what we were talking about just a moment ago, right? What does it do to the value of the copywritten work as a whole, right? If you reproduce it and give it away, the value is greatly diminished. People don't pay for what they can get for free. The Digital Millennium Copyright Act of 1998 makes it illegal to circumvent the encryption and other anti-piracy technology that protects commercial software and outlaws the manufacture, sale, or distribution of encryption-breaking devices that can be used to illegally copy software. This act requires that webcasters pay licensing fees to record companies. Next up is patents. Patents protect a product, process, invention, machine, or plant produced by asexual reproduction. By protection, what we mean is it grants the holder an exclusive right to his or her invention, granting them a virtual monopoly. No one can use it without their permission. Now, in order to get a patent, the subject matter of the patent must be patentable. All right, what's the requirement to become patentable? Well, the object must be novel, that means new, useful, and non-obvious in the current light of technology. Now, when a patent is granted, the holder has that virtual monopoly for 20 years. Now, next up is remedies. The idea of a patent, or the idea that's central to a patent, is that if someone takes their time, their effort, their resources, and comes up with some invention, they should benefit from it first. Right? This is so important in the United States that this is part of our Constitution. Right? The Constitution of the United States, in this one case, grants a patent holder a virtual monopoly on their invention. Now, one of the reasons, and I'm sure this is obvious to everybody, is to convince people to invent. If you spent your time, your effort, your money, and you created something new and anybody could take it from you just because they saw it, how fair would that be? That is one of the issues that the United States and most countries have with China, right? China does not honor anybody's patent laws, any intellectual property laws. So if you have something produced in China, right, as per Chinese law, they are free to copy your invention and set themselves up as your competitors, really taking away a lot of the value. So that's one of the issues. With that being said, let's move back to remedies. Remedy number one, monetary damages. Right? Monetary damages are generally whatever profits the patent infringer earned from your invention, and whatever other fees, other damages that you can claim, issues that hurt you financially, court fees, loss of work, bills, healthcare bills related directly to that breach, so monetary damages. Next, of course, is an injunction. And as we've stated before, an injunction is simply an order to stop someone from doing something. There are restrictions on patent holders. A patent holder may license the use of an idea for royalties, meaning they're paid to let you use their thing, provided that the holder does not enter into a tying arrangement or engage in cross-licensing. Right? Basically what that means is once they license for use, they're really limited on telling you how you can use it. They can't tie your hands up, basically. Right? is subject to the agreement. Additionally, right, if they license you to use a patent, they really can't engage in cross licensing, mainly licensing it up to multiple people, right, to be used in the same way. All right, let's talk about how patent litigation takes place. After the initial pleadings are filed, that would be the summons and complaint, the patent holder must file a patent infringement contentions that explain in detail how the defendant infringed the patent. Now, the reason why you have this separation is patent law is a whole separate area of law, and you have to go to a patent court, right? The lawyers are trained specially, as are the judges when dealing with patent infringement issues. Now, one of the things that's not really clear, right? The reason why you have to file these patent contentions, right, and explain in detail how the defendant infringes is because someone can steal your idea in part. They don't have to steal the whole thing. So you have to show exactly what the defendant did, exactly how they infringed on your idea, on your invention. Because this is the law, we have to talk about things from both sides. The defendant must file an invalidity contention that explains why the ideas in the patent already existed in the public domain. And they must provide copies of all of the publications that contained those ideas. If you recall, in order to get a patent, the idea, the invention had to be novel. Novel means new, right? It had to be useful and not obvious in the light of current technology, right? If you can show that that idea was already out there, right, it's not novel. So that would be your defense. Now, this is the law, and in the law, the devil is in the details. So the parties have to identify all of the terms in the patent that have special definitions and provide the proposed definitions of these terms. At this point, the court considers the proposed definitions and decides how the terms will be defined for the purposes of the litigation. After this point, the patent litigation generally proceeds as any other case. It is a special area of law, right? Because everything you're dealing with in the patent is generally new, right? But once those things are ironed out, it's a regular lawsuit. The America Invents Act. The first person to file a patent application in the United States for an invention will be deemed to have the rights to the invention. The Act expands the types of prior art that may be considered for the use by the United States Patent Office when granting a patent, thereby arguably making it more difficult to obtain a patent. The Act makes changes to the reexamination process and makes the process more like litigation by allowing discovery requests during the process. The Act prohibits a plaintiff from filing one suit against many unrelated defendants, a practice that typically increases the number of patent infringement cases filed. The Act makes it easier and more affordable for small businesses and sole proprietors to file for patents. Trade secrets are process, product, method of operation, or compilation of information that gives a business person a competitive advantage. Basically, what we're talking about is how a company does something that's different than the way its competitors engage in the same thing. Trade secret laws allow the holder to sue for violation if he or she can prove certain conditions exist. Now, the purpose of a trade secret is to protect your proprietary information. It's not a patent, but it's your methodology of doing things. An example of methods might be if you work in an art gallery, the way you collect information about your clients, right? A client book where you know birth dates, special occasions where they might buy art, and the list of the artists that they like. right? It may be the way you communicate with them, right? If it's different than the way other galleries would do that, right? That would be a trade secret. Now, with all things, the violations for trade secrets are pretty consistent. Monetary damages, how much did the theft of the trade secret cost you? And once again, the injunction, which again is the order to cease and desist, to stop doing what you're doing. International protection of intellectual property has always been an issue that comes to the forefront. If something is produced, copywritten, invented, patented, designed, trademarked in one country, what would stop someone in another country from using the same thing? Right? This is a problem that continues. If you read the news, business news, you'll know that one of the big issues that most of the world has with China is China does not honor intellectual property laws from any other country. If you manufacture a product in China, as per Chinese law, you have to give up your patent and allow their folks, their business people, right, to manufacture essentially the same thing. Basically, you do the work and they get the benefit. Well, this has been a struggle for a very long time, and it's been addressed in several ways. There are treaties administered by the World Intellectual Property Organization, which is a special arm of the United Nations that tries to protect intellectual property rights. The Berne Convention of 1886 was an early attempt to protect international intellectual property rights. When we go specifically into copyright material, right, there's a Universal Copyright Convention that was signed in 1952 and then revised in 1971 that tries to protect creative works that are contained in a durable medium. Right? Think for a second how easy it would be. Let's say you were a Frenchman to find a book that's a #1 bestseller in the United States written in English and just copy it into French, put your name on it, and give yourself credit as the author. Right? The Universal Copyright Act or Copyright Convention attempts to prevent this from happening. You have the Paris Convention of 1883, another early attempt to protect intellectual property. And in 1994, agreement on trade-related aspects to intellectual property rights. Right? All of these things attempt to protect intellectual property rights of the holders. Now, the reason why I keep saying attempt, once again, has to do with national law versus international law. These treaties and conventions are only applicable to the signatories. Those are the countries that actually signed on. If there are other countries that did not sign, it's very, very difficult to enforce them. All right, so intellectual property is an important right, but outside of your home country, sometimes it's very difficult to protect.